Hello, everybody. A very good evening to you, ladies and gentlemen. I'm sure our audience is enjoying the court vacation and everybody is in a festive mood as I join you all today. I'm also happy to announce and welcome you all to the 30th webinar. That's right, it's the 30th webinar of the continuous webinar series organized by the Bar Association of Sri Lanka, which has been conducted over the past 8 months. Needless to say, organizing these webinars each week continuously without a break takes a lot of effort and manpower behind the screens. The management committee of the Bar Association of Sri Lanka, that is the president, Mr. Kalinga in the Tissa President's Council, deputy president, Mr. Shavindra Fernando, President's Council, secretary, Mr. Rajiv Amarasuriya, assistant secretary, Mr. Pasindu Silva, and treasurer, Mr. Nalin De Silva, must be given the credit for having these webinars up and running each week with the support of the staff of the Bar Association of Sri Lanka, and very specially with the help of Mr. Saranga Hettiarachi, the head of IT, who handles the technical aspects of the webinar each week. With the support of them and other numerous people, the panelists and the moderators who have contributed to the 30 webinars held so far, and of course, all of you, our viewers, we are happy and able to continue this webinar series. And owing to the overwhelming response, we were even able to start a second webinar series in Sinhala. Despite the COVID-19 pandemic and the chaos it has caused, the BASL indeed seems to have had a very busy and a fruitful year. So much so that even right now, members of the BASL Management Committee are in Dambulla participating in the Max Planck Foundation Training of Trainers workshop in economic, social and cultural rights. Joining us all the way in Dambulla, we now have Mr. Rajiv Amarasuriya, the Secretary of the Bar Association of Sri Lanka, also the Chief Organizer of this webinar series, who will address you all now.
Thank you, Uma. Good evening, ladies and gentlemen. Today we complete 30 BSL webinars under series 1.0, and it is a momentous occasion for all of us. We have been able to provide continuous professional development through this webinar series every week for 8 months consecutively. In addition, we have also been able to reach out to our entire membership without any geographic constraint, and even to those residing overseas. At the outset, I take this opportunity on behalf of the Bar Association of Sri Lanka to thank our regular viewership, our membership who tune in every Saturday at 5:30 p.m. to participate in these BSL webinars. On average, the regular viewership is more than several thousand for these webinars, which I made to understand is a very high number for webinars. In addition, all these webinars are hosted on the BSL YouTube channel, which can be easily accessed at any time. It was not an easy task conducting 30 webinars continuously every week for the past 8 months. I take this opportunity to thank the members of the Management Committee of the BSL President, Mr. Kalinga in the Tissa President's Council, Deputy President, Mr. Shavindra Fernando, President's Council, Treasurer, Mr. Nalin De Silva, and Assistant Secretary, Mr. Pasindu Silva, for all the encouragement and support given to conduct these webinars continuously and make it an important feature of the activity calendar of the BSL. Special mention and thanks to Assistant Secretary Mr. Pasindu Silva, who has been a tower of strength to me as he meticulously coordinates the arrangements every week with precision and detail. He is a perfectionist, and I'm most grateful to him for his steady and dependable support and advice given. Also to my junior, Ms. Ann Devananda, attorney at law, who is also always available and online to support the BSL team, and to my other juniors, colleagues and friends for the many ideas and suggestions given to continuously improve these webinars. I will be failing in my duty if I do not thank Mr. Ushan Uberatna, attorney at law, who introduced to me this concept of webinars around September 2019, well before COVID, which prompted me to include the commencement of these webinars in my proposed action plan, which I presented to the membership around that time. The outbreak of the pandemic fast-tracked the implementation of this series. I take this opportunity to thank all the resource persons we have had at these webinars for sharing their knowledge and expertise with the membership. We could not have shared expert knowledge in 30 different areas of law if not for the support we have had from our resource persons from across the bar. I must also thank our members, Mr. Anya Gunawardana, Ms. Uma Vijayasuriya, and Mr. Shahara Hera, who have compared these webinars. Tanya did many at the beginning, and Uma joining thereafter, and Shahara also joining, and I'm deeply appreciative of their support. I must also take this opportunity to thank the BSL support team, the CEO, Mrs. Surani Samrasekara, and the staff, and especially Mrs. Sarang Hettiarachchi, the BSL head of IT, who has provided the technical support continuously. We have now completed 30 webinars, and we hope to continue the series for as long as we can. We have also just commenced a new series, Series 2, which is conducted in Sinhala every Tuesday evening, and we will also hopefully commence soon, Series 3, which will be conducted in Tamil. We have a very interesting webinar lined up today on arbitration and recent trends with a very distinguished panel, including Justice of the Supreme Court, His Lordship, Honorable Justice H.M.D. Nawaz. Without taking any longer, I will now hand over the proceedings to Ma to proceed to introduce the expert panelists today. Thank you.
Since this webinar series is a brainchild of Mr. Rajiv Amarsurya, it was wonderful to hear from him. Thank you very much, sir. Once again, I welcome all of you to today's webinar, the 30th one. And today we intend to discuss matters of arbitration. And the topic for today is key issues and recent developments in arbitration. Let me now introduce to you the fabulous panel of experts who will be sharing their knowledge with you all. First, we have Honorable Justice A.H.M.D. Nawaz. Justice A.H.M.D. Nawaz was sworn in as a judge of the Supreme Court in December 2020. Prior to his assumption of office as the president of the Court of Appeal, Justice Nawaz had been functioning as a senior justice of the court and dealt with several provinces of the law, such as civil and criminal appeals and judicial review. Before Justice Nawaz was elevated to the judiciary as a judge of the Court of Appeal in 2014, he was serving in the Attorney General's Department. Justice Nawaz is a Chevening scholar who pursued his LLM in commercial and corporate law at King's College, London. In the year 2008, he won the Fulbright Humphrey Fellowship and pursued his second LLM in transnational criminal and commercial law at Washington College of Law, American University. Justice Nawaz also secured a third Master of Laws in Constitutional Law and Administrative Law from the Faculty of Law of the University of Colombo. He holds an LLB degree from the University of Colombo. Justice Nawaz, while serving in the Attorney General's Department, appeared for both domestic and international arbitrations and later lectured on arbitration. We are happy to have you on board, sir. Next, I would like to introduce to you Dr. Asanga Gunawardana. He has over 25 years of legal practice, and his practice areas are particularly focused on construction and commercial law. He holds a PhD from the National University of Singapore and a LLM from the University of Warwick on international commercial arbitration. Dr. Gunawardana is currently the chairman of the Sri Lanka International Arbitration Centre and is also a member of the arbitral panels of the Asian International Arbitration Centre, Thai Arbitration Centre, and the SAARC Arbitration Council. He is currently the lead counsel of Colombo Law Alliance, which is a law chamber specialized in commercial arbitration and litigation. I'm also pleased to introduce to you Mr. Hiran M.C. Dialvis. He is an attorney at law who has been in practice for over 25 years, specializing in civil and commercial law, financial and securities litigation, and commercial arbitrations. He is a law graduate of the University of Colombo and holds postgraduate qualifications from the University of London in international dispute resolution. He is also an arbitrator and a fellow of the Chartered Institute of Arbitrators, London, and the Malaysian International Arbitration Centre. Mr. Dialvis is also a member of the Board of Governors of the Sri Lanka National Arbitration Centre and also its honorary chief legal advisor. He also functioned as the director of the Colombo Stock Exchange and was the chairman of the Arbitration Committee and Dispute Resolution Committees of the Colombo Stock Exchange. He has also previously been an independent director of several companies and other charitable funds, as well as being a bar counselor. Next, I would like to introduce to you Mr. Harsha Fernando. Mr. Fernando is an attorney at law with over 25 years of experience. He specializes in civil, commercial, and public law. He offers commercial negotiations and mediation services and provides training and strategy consulting. He works as a consultant and trainer with Sea Change Partners of Singapore, Accordance USA, and is an international consultant to the Asian Development Bank. He has also provided consulting services to the World Bank, International Organization for Migration, European Union, International Securities Consultancy of Hong Kong, the UNDP programs, and the National Procurement Commissions. Mr. Fernando was in the Attorney General's Department from 1997 to 2011. He holds a Master's in Business Administration and Executive Master's in Management. He also holds an LLM in Regulatory Law and Economics from King's College, London. He is a Chevening Scholar, a Nanyang Fellow of Singapore. He also secured the Most Outstanding Young Person of the Year award for legal administration in 2011. And now I would like to introduce to you the moderator of the day. We have with us Mr. Janaka Basuri, attorney at law. Mr. Basuri graduated from the University of Kelaniya with a Bachelor of Arts. Being an attorney at law, a company secretary, and a legal consultant, Mr. Basuri handles an array of legal work ranging from commercial law, company law, corporate law, investment law, intellectual property, civil litigation, and contract law. He is also a founder director of Tribe International Private Limited, a company that provides total corporate solutions to local and international corporates. So that will be your panel of experts for today. Without further ado, we now head into the webinar of the day on key issues and recent developments in arbitration. I leave you in the capable hands of Mr. Basuria. Have an enjoyable session.
Thank you, Ma, for those generous words. As you stated quite rightly, today's webinar is a significant one, as it is the 30th of its kind organized by the Bar Association of Sri Lanka. We must congratulate the BASL and its office bearers for this yeoman service. Ladies and gentlemen, our first speaker for today is Honorable Justice AHMD Nawaz, Judge of the Supreme Court of Sri Lanka. It's our pleasure and privilege to have you here with us in this webinar, sir. Before we move on to his lordship's speech, let me quote a famous saying popular in the arbitration industry, which sets out the relationship between national courts and an arbitration system. I quote, "The relationship between national courts and arbitral tribunals swings between forced cohabitation and true partnership," unquote. By choosing to arbitrate, parties agree to forego local remedies and to participate in the proceedings administered by a neutral and private means of justice, and to be bound by the award so rendered. However, on the other hand, one cannot ignore the fact that, may I also quote again, national court could exist without arbitration, but arbitration could not exist without the courts. The real issue is to define the point where this reliance of arbitration on the national courts begins and where it ends, unquote. Therefore, in such context, it's paramount for us to understand the judicial thinking and perspective on various aspects of arbitration. With that, may I humbly invite His Lordship, Justice Nawaz, to enlighten us on the aspect of recent trends and judicial perspective on arbitration. Over to you, sir.
Right. Thank you very much. Let me share some of the slides that I prepared for this evening. Right. Okay. Right. Now, this is an exercise. I must say that 30th webinar is an exercise in alternate dispute resolution, which focuses on arbitration. And if you talk of arbitration, some salient points and recent trends, you would immediately come into contact with the judicial role played by the national courts in the conduct or in the supervision of arbitration that takes place in the sea. So I would concentrate on this interaction between courts, national courts and arbitral tribunal. And in the process, I will throw some salient points for you to think about. And then, since I was told that the audience comprises junior members of the bar, I really wanted to pitch it at the level of them and then take it to a higher state. So in the circumstances, what I would do is I would just say that arbitral tribunal is the product of autonomy, party autonomy. In other words, even though arbitration agreement that is agreed upon by two parties gives rise to resolution process, it is underpinned. In other words, the arbitral agreement is underpinned by various other processes surrounding it. It doesn't, the content of an arbitration agreement cannot be looked at alone unless you have looked at the other surrounding circumstances. So one such surrounding circumstance is the role played by national courts. Of course, there are other surrounding factors that surrounds an arbitration agreement, such as the rules enacted by institutions. If it's an institutional arbitration, there are two types of arbitration: ad hoc arbitration and institutional arbitration. If it is an institutional arbitration, it will be governed by rules such as ICC rules, and I would say the arbitration agreement cannot exist alone without reference to the rules of ICC. And then the national law. The national law comes into play if you have not chosen the national law or if it is implied into the arbitration agreement. Then comes the international treaty, such as the New York Convention, that comes into play at the time when the winning party in an arbitral award takes it for enforcement. Now, if you look at it, the true meaning of an arbitral process doesn't find its full import unless and until we understand the surrounding factors around an arbitral agreement. So now, the rule is, they say, right, when parties confer jurisdiction on an arbitral tribunal, the rule is that there must be minimal intervention by courts. And that spirit is found or mirrored in Section 5 of the Arbitration Act, which is known to many. In other words, an arbitration agreement has to be given primacy of place by the court if an objection is taken that the court has no jurisdiction, and then it has to be, the matter has to be referred back to arbitration. A case to look at is Bino Tires, decided by the Supreme Court. That's where the Justice Massouf ruled on arbitration rather than for a suit in litigation in court. In other words, the trend there in that judgment is to look at an arbitration-friendly approach towards arbitration clauses. So, keeping that in mind, the courts have to stay their hands off arbitral processes, except when they are permitted to intervene. So that's what we have got to look at. Now, if you look at the model law, now we are still stuck with our old law, the Arbitration Act number 11 of 1995. If you look at the, of course, this has to be amended. This needs revision. This legislation, which came about so many years ago, it makes it very clear. It says it says, it is necessary to make legal provisions to give effect to the principles of the Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958. So in other words, it gives effect to the New York Convention, and also it takes away the old field procedure that was employed deal with arbitration, and then it goes on to provide for the arbitration procedural matters, tweaking the main Untittled model law, which has also undergone changes in the recent past, but we have not incorporated those changes into the Arbitration Act number 11 of 1995. That's a matter for Dr. Asanka Gunavansa to deal with. So therefore, I will not go into the recent amendments that have been made. So virtually, there are two international instruments that play a part in the Arbitration Act number 11 of 1995. One is the Untittled model law. It's just a model law. It doesn't mean that we have got to follow it verbatim, right? We can tweak it. We can incorporate it in the way we think is necessary for Sri Lanka. So that's what we have done. But the New York Convention, which is also implemented by the Arbitration Act number 11 of 1995, it's a convention to which we became a party. So now the first point that I made initially, that an arbitral process in Sri Lanka or anywhere for that matter is underpinned by international instruments and other surrounding factors, is manifested in the Arbitration Act itself. Now who can intervene in arbitration? The Untittled model law speaks about a competent court. You know which competent court it is. The High Court is designated in the Arbitration Act as the competent court that can give assistance and supervision. I also have to draw your attention to Article 11, this of the New York Convention, to which Sri Lanka is a party, and we are a dualist nation. As a result, we incorporated this into this treaty we signed into Arbitration Act number 11 of 1995, and in that we have specifically stated that the particularly enforcement mechanism is of the New York Convention, and that convention says most courts are obliged to enforce the agreement to arbitrate. That is why in the Binotai case, now whenever any court deals with an arbitration agreement, it has to be it has to be inclined to enforce the arbitration agreement despite minor defects in the arbitration agreement. Now, I recently was told that an objection was taken to an arbitration agreement on the basis that ICC was mentioned, but the word rules were not there. The word, when you draft an arbitration agreement, sometimes you miss out on certain words. That itself gave rise to an objection. But if you can look at the spirit of the New York Convention and the model law, Untittled model law, judges have to just reject those. Arbitral tribunals have to just reject those in favor of arbitration. Of course, there are clauses which are classified as pathological, clauses which cannot survive at all before an arbitrator. That's a matter that, of course, has to be dealt with in a different lecture or speech. But we are not dealing with pathological clauses that kill an arbitration clause. One has to be wary as to how one should draft an arbitral clause, stopping short of drafting pathological clauses. Anyway, the spirit is towards enforcement of arbitral clauses. Then, when you have those surrounding laws around an arbitration agreement, I said at the beginning, arbitration agreement doesn't have a content, does not find its meaning unless these laws govern them. So arbitration agreement itself has to have a law to govern it, because if you have a law to govern the arbitration agreement, and now usually in a contract, now this is, I'm just pitching it for the beginners or some people who are just joining them. I know some of the magistrates are there in the audience. So now arbitration agreement is usually tucked away in a corner in a main contract in a one paragraph. But that agreement to arbitrate must have a law to govern it. Then only it gains validity. Any contract. Now, in a main contract, there are two contracts. One is the main contract dealing with the rights and liabilities of the parties, if it's a construction contract or if it's a and the other one is the arbitration agreement, which only says if there is a dispute arises or difference arises between the parties, the matter has to be referred to arbitration. So there are two contracts. Both contracts, one contract is called the main contract, the contract that will the breach of which will give rise to the dispute. So that also has to be governed by a particular law, English law or Sri Lankan law. Arbitration agreement itself has to be governed by another law. Because we have to have laws just to look at their validity. And then if the arbitral process takes place in a particular country, of course, now you can't travel, even if you say that arbitral seat is London, you can certainly travel in cyberspace and have your kind of online arbitral process. So, but still, the arbitral proceedings now, which law will govern arbitral proceedings? Now, it's called the law that governs arbitral proceedings is called the Lex Arbitri. Professor Mistelis is in an interesting article published in Journal of International Arbitration in the United States. He categorizes them into external lex arbitri and internal lex arbitri. In other words, when the arbitrator conducts the arbitration, the procedure has to have a law, like Arbitration Act number 11 of 1995, or the rules of ICC, or external arbitry. In other words, when you seek the supervisory role of the court to guide you to take the proceedings to a close, you have to seek the assistance of the court, and that is called the external arbitry. And then the law, there must be a law governing enforcement. Now, if it's an enforcement procedure, I have already told you, it's the New York Convention that governs it. That is incorporated in Arbitration Act number 11 of 1995. So the rule is don't interfere, but then there are stages at which the courts come in, and that's where commercial arbitration, commercial court has its battles. It can be at the beginning of an arbitration. Now, as I said, Binotire is somebody filed a case there and then said it must be initiated in court. He came by way of plaint. But then the other defendant said, no, this is governed by an arbitral clause, and then it has to go for arbitration. Then the plaintiff retorted, no, the arbitral clause is invalid. Then that question was gone into, and finally it went all the way to the Supreme Court. The Supreme Court enforced so one issue is it begins, the court interference begins at the beginning of the arbitration. It can also occur during arbitral proceedings when the proceedings have begun, and then you need to get measures of interim protection. Of course, it will be dealt with by Mr. Hirande Alvis. So in such a situation, you go to court during arbitral proceedings. Then at the end of the arbitration, you identify where the assets of the losing party are located. The arbitration can take place in Sri Lanka, but if the assets are found in Singapore, you take the award all the way there to enforce it. So that's Singapore is New York Convention compliant, and then they will enforce it in the way we would enforce this in the country. Then So why we rely on domestic courts, it's all because enforcement arm is sadly lacking in arbitral tribunals. Then thereafter, so that is, you can look at that bullet point. That is the bullet point that Mr. Janaka Basurya mentioned. He picked it up from Redfern and Hunter. Right, it's there as large as life in the 6th edition. National courts could exist without arbitration, but arbitration couldn't exist with national courts, which is a famous catchword mouthed by lots of arbitral persons. Then, and it also says the courts really strike a balance between cooperation and interference. It's not a forced cohabitation, right? The new edition says it's not a forced cohabitation, it's rather a cohabitation between courts and arbitral tribunal. So now, then, I know the time constraints, but then I will rush it. Now, Article 11, when I say articles, I'm speaking about the model law, Uncitrall model law. Right, you can seek the help of the competent court to constitute the arbitral tribunal. That is mirrored in Section 7 of Act number 11 of 1995. It's section. If you look at Section 7, there are a lot of battles that go on in the Commercial High Court. Now there are situations given in which type of cases you can go and get arbitral tribunal appointed. Such a situation took place in Wakachiku Construction Company Limited versus Road Development Authority. I must take this opportunity to say, right at the beginning of this case, it was Mr. Harsha Fernando who appeared for the Road Development Authority, but I took over when he left the department. And then thereafter, it went all the way to the Supreme Court. And I also had the pleasure of representing the Road Development Authority there. And quite a competent and well-known bench, they decided this on the 6th of what happened there was this problem about Road Development Authority did not agree to the arbitrators nominated by the Chinese company. So then we stuck to our refusal all the time, and then what we did, we mounted a Section 7 application and asked the High Court judge to nominate somebody. So then when that nomination took place, the leading Queen's Counsel or King's Counsel went all the way to the Supreme Court and challenged that nomination on the basis that the nomination is bad and it cannot be carried on. But I took the argument that since this could be taken up later when enforcement is sought to be made against the Road Development Authority. In other words, since this could be taken up in an enforcement proceedings, you cannot take it up from the High Court to the Supreme Court. In other words, inherent jurisdiction of the Supreme Court cannot be invoked in such a situation. And my argument was upheld in that case. Right. It is also reported. Then also you can seek the help of the arbitrator of the High Court if there are doubts as to the impartiality or independence of the arbitrator. And so now Section 10 mirrors that Article 13, and challenges to the jurisdiction of the arbitral tribunal is done in that way. And so you can take the challenge. First, you take it before the tribunal, and then thereafter you take it. You bring it before the High Court. This is an interesting section, Section 11, taken off from Article 8 of the model law. You can see how model law, Uncitrall model law, has been tweaked and brought into Sri Lanka by Act number 11 of 1995. But I must caution you that the Uncitrall model law has undergone huge changes, but we are yet to copy it into our legislation. Now, so this is you challenge the arbitration agreement. Now, if the arbitration agreement has no validity, on the basis that it is contrary to public policy, or it has fallen by the wayside, or it cannot be performed, then any party to the arbitral proceedings may apply to the High Court for a determination of that section of that question. That's what Article 8 says. But our section is Section 11, and Section 11.2 says, right, even when that application is made to the High Court, the arbitrator can go ahead and go ahead with the proceedings until the High Court come. So how do you interpret this section? There are two schools of thought. Of course, Redfern and Hunter. He says when the court decides this jurisdictional question, if the court decides that there is no arbitration agreement, that's the end of it, and the arbitration must terminate upon that determination. In other words, it is the court which has the final say, according to Redfern and Hunter. And 11.2 gives that indication, if one can interpret it, but it has not so far been interpreted. I don't know whether it has been interpreted in the High Court, but I tried it some time ago. But then, but we settled the matter halfway. Because of that, we have still not conclusively taken a view on this. Then even if you have not taken that objection to the arbitral agreement on the basis of invalidity, you can see Section 34, subsection 1, A, Roman numeral 1. That section says you can still take it up at the seat of arbitration when the arbitral award is given. And now, say for instance,
sir, I'm sorry to barge in at this point of time.
Arbitration takes
Can you hear me, sir?
place in Singapore, and Singapore award is rendered. Then you see, I can hear you. Can you hear me?
Yes. Yes, we reach you, sir.
Yeah.
You have another 2 minutes, sir, if you don't mind.
Okay. Now, right, we can share this. I just
yes,
want
definitely, sir. We will share the slides.
Yeah.
And
I just want to show this.
Yes.
This, right, and then finish this. Right now, another interesting thing that takes place is, as I said before, what law should govern the arbitration agreement, right? So now the latest case, which is making us splash right at the moment in the UK, is this case, Enka versus Chubb, UK Supreme Court, right? Which is the latest case, which virtually holds that it is the seat law. It is the Enka. If you just Google Enka versus Chubb, you get this case. It is the seat law that will govern. There are other cases in C versus D 2007, but this case, very good analysis. I enjoyed reading this, but it's 3-1. The Supreme Court, impeccable, and so I would recommend that you must read this. If you have not agreed, you have got to follow the seat law to that will govern the arbitration agreement. And then what are the new trends? The new trends, LCIA rules are getting updated. Then ICSID rules are getting updated. So we have got to come and another one is the seat recognition. The seat law must be given primacy is also was decided in this case. And if you want to get this case, high-end case, right, the summary of the judgment is in this. In other words, if you just can go to New York Convention website to get this case, right? So in addition to the UK Supreme Court decision, you also have this decision. Then of course, Asha might talk about this, the Singapore Mediation Convention to 2019 just coming, right? Then artificial intelligence is taking over in arbitration. This is in this website, you get that, right? And I just wanted to speak about public policy. Well, maybe there are problems in public policy, but then I came across a very interesting judgment from India, right? This is being reported right at the moment. And Justice Nariman, he's well regarded in now in Karya versus Prismian, right? Recently, he downloaded, he said page 39, he says, the notion of public policy, he follows the Singaporean judgment and says, it has to be narrowly interpreted. It has to be narrowly interpreted. I take a slightly different view, right? Well, I'm running short of time, right? Come from Nariman J on that. Right. Okay. And thank you very much. Right. Others can take.
Thank you, Justice Nawaz, for that explicit and explanatory presentation. We are so much privileged to listen to that those slides. I'm sure the participants will be given a copy of it or emailed presentation at the end of this webinar. Thank you, sir. Thank you. Our next speaker in this webinar is Mr. Hirandi Alvis, who himself is an expert in the field of arbitration and an experienced commercial counsel who is passionate in developing arbitration in Sri Lanka. Mr. De Alvis will speak to you about an important aspect of arbitration, and that is interim measures of protection and the latest trends in arbitration. Now, if you may see the UNCITRAL model rules, ICC, the SIAC, any arbitration rules for that matter provides for such interim measures as they are an important and integral part of the arbitration legislations. The French version is named the Les Mesures Conservatoires et Préservatoires. In Swiss law governing international arbitration, it is called the provisional and conservatory measures, implying such measures are used in order to maintain the status quo ante. If I may, our own Act 2 provides for such reliefs. Therefore, it is vital that we delve into such important topic today. Over to you, sir.
Thank you. Good evening, Janaka. Thank you. And with the permission of the distinguished ladies and gentlemen, I'll delve straight into the topic which has been given to me is interim measures of protection and the trends, the latest trends. So I do not, the time constraints, I do not wish to delve into the basic matters of the Arbitration Act, etc. What I can say is the whole approach now would be that an arbitral award or a court judgment cannot be made nugatory. This cannot be an academic exercise. So therefore, interim measures of protection may come into play in the near future more often than not. Now, why is this so? I'm mindful of the time constraints, also mindful today is the last day of term and normally would have had footlights. So I will also have an interim talk, but why do we need interim measures of protection? Now, as in the normal law, preservation of the status quo ante is of vital importance for any party trying to adjudicate their disputes in court. So as the judgment says, as the court says, judgments can't be made nugatory. Then the whole dispute resolution process in a law-abiding country can be made futile. So it is imperative that there must be effective enforcement of the existing laws. Now, one of the laws for the enforcement of contracts or adjudication of disputes is the Arbitration Act. Now, if a party selects under party autonomy to go through an arbitral process contractually without recourse to a court of law, if that final award is going to be rendered nugatory, then the whole exercise is useless. This has serious implications for the rule of law, certainty of commerce, etc. Therefore, if the subject matter of the dispute is dissipated in the meantime of this adjudication, that is the reason interim measures of protection are vital. As Janaka mentioned, some of the rules specifically provide for it. I'm not going to repeat it. So the importance of interim measures has been recognized in our law in a gamut of various statutory jurisdictions, as you know, Judicature Act, Civil Procedure Code, etc., etc. Now, the Arbitration Act also has specific provisions in relation to interim measures of protection, interim measures. Now, delving into the Arbitration Act, one must be mindful, firstly, to keep the cornerstone of the Act, one of the cornerstones, Section 5 of the Arbitration Act, in mind. That is, a court would not have jurisdiction if the other party objects to the exercise of the jurisdiction of courts. It is in that background that all other measures in relation to interim measures, if you are seeking through court, should be done. So it is of vital importance, and it is an obvious measure, but parties, if they are seeking interim measures through a court, should be very mindful that there is a statutory bar to jurisdiction in the contractual clause. So it is in that very narrow parameter that you can come to court and preserve the status quo. Now, if you come to the Arbitration Act itself, there is specific recourse to what is called interim measures of protection in Section 13. I will just delve into it briefly so that to get an idea of what is important. Now, the Act specifically refers to an arbitral tribunal, once it is formed, granting interim measures of protection. That is to protect or secure the claim, etc. And to provide that the party ordered can also be asked to provide security, etc. Now, it is also important here, in my opinion, that it says that it is in exceptional cases that an interim order can be made without hearing the other party. In my opinion, it is of paramount importance that both parties are heard in arbitral tribunal prior to any interim measures being granted. It is in very, very exceptional situations only that interim measure should be granted by a tribunal, because if not, the whole credibility of the entire arbitral process would be cast in doubt. Now, once an arbitral tribunal makes interim measures of protection, what do? The practical reality for practitioners is that an arbitral tribunal award can be ignored. So then what do? There is no coercive force in a tribunal. Therefore, the Arbitral Act provides an arbitral award can be enforced, that is interim measures of protection, in the High Court. And it's very important, it's specifically recorded that the application to the High Court for the enforcement of the interim measures shall not be deemed incompatible with the Section 5 waiver. So the specific recourse is given to ignore Section 5 and go to the High Court for the enforcement of interim measures of protection. This is of vital importance. If a party refuses to follow the interim measures of protection, recourse is made to go to the High Court and to get that enforced. The practical realities of that is also a bit difficult, but we'll come to that in due course. Now, leaving the Arbitration Act, one can go back to the interim measures that are possible in the normal courts through the Judicature Act. Now, this also has been strictly construed because, as I said, Section 5, there's jurisdictional bar. However, as set out in the celebrated case of Baxon's Textiles, 51 NS/97 Court of Appeal by Justice Edusiria, very clearly sets out the law in relation to this. That court held no doubt that a dispute has to be referred to arbitration. Now, this was a case in relation to possession, but however, it had an arbitration clause. So court upheld and recognized the principle of section 5, no jurisdiction. However, in relation to interim injunction, court said, until the final dispute is settled or an interim order is made by the tribunal, a party is entitled to go before the district court and to obtain interim relief to maintain the status quo. A brilliant exposition of the law by our judiciary on basic principles, you preserve the status quo. So that has provided the opportunity for a party in limited circumstances, pending a recourse to the arbitral tribunal, to maintain the status quo under the Judicature Act. This has been now accepted widely in our courts as well. Now, the development of the law, I am positive because I believe if you see the analysis of our judgments, our courts have stepped in and brilliantly conceived legal precedents for the development of the existing law. For example, Silavati Mallava, where the wrongdoer should not get a benefit from his own wrongdoing, developed by our courts. Then you come to the celebrated Felix Das Bandaranaike case, 1981 2 SLR. Those sequential tests for the granting of an interim injunction has to be followed even in relation to interim measures of protection by an arbitral tribunal. It is in a twofold basis I say this. An analysis of the law in that judgment clearly sets out the steps and the reasoning why interim injunction is necessary. An analysis of the institutional rules which provides for interim relief coincidentally also has these basic principles incorporated into it. Therefore, I would recommend the Felix Das Bandaranaike judgment reasoning for any arbitral tribunal looking at approaches for interim measures of protection. I won't repeat. For example, prima facie case, balance of convenience, irreparable loss of and damage. So these sequential tests must be met for an interim injunction to be granted. Very briefly, I won't go in detail. Supreme Court 33A/2012. It's in the Bar Association Law Journal 2013 as a detailed exposition of the law that has developed up to now in relation to interim injunction. So especially for the younger members of the audience, if you want to delve into how this law has developed over a period of time brilliantly by our courts and precedents, I would recommend that as well. So this judgment also summarizes the law on what basis interim measures of protection should be and can be granted. Now, so therefore, the law has to be practical for the enforcement of interim measures of protection. Now, as I said earlier, preservation of the status quo ante is the cornerstone of granting interim measures of protection. If parties are going to arbitration, appoint arbitrators, appoint lawyers, and argue for a year, and the whole purpose has been dissipated, the assets, it has no purpose, as I said earlier. Now, even in foreign jurisdictions, this has been very clearly established more strongly than in Sri Lanka. For example, the Singapore International Arbitration Center rules, UNCITRAL model law rules, London Court of International LCIA rules specifically provide in their rules for interim measures of protection. And I refer to the thinking, I will just refer to some of the UNCITRAL arbitration rules for interim measures. These are the guidance they give. For example, interim measure has to be a temporary measure to maintain or restore the status quo pending the determination of the dispute. Preserve evidence that may be relevant and material to the resolution of disputes. It has about 8 other points. Then most importantly, a request for interim measures addressed by any party to a judicial authority shall not be deemed incompatible with the agreement to arbitrate or as a waiver of that agreement. So that even the UNCITRAL rules provide for the mechanism to use the power of the court to enforce or obtain interim relief for the preservation of status quo. So even with the present law, our judiciary has met this test and protected this right. Now, of course, there are arguments and counter arguments always in mind. The jurisdictional issue has to be dealt with. Now, the thinking for this interim measures and the counter arguments is also explained in an interesting English case, which you at leisure maybe, but it's called the Pearl Petroleum case versus the Kurdistan Regional Government of Iraq. To English case 2016 4WLR. Now in this case, in relation to a petroleum dispute, the claimant Pearl, during the course of the arbitration, was not paid a certain amount of monies by the regional government. So the whole arbitration was going to be made nugatory. Therefore, they applied for interim measures of protection to the arbitral tribunal itself, asking, amongst other things, that the periodical payments for the oil be made. The tribunal upheld that, granted interim order, that was ignored. Then the tribunal made what is called a peremptory order to enforce that order. That was also ignored. Thereafter, the party went to the High Court. Then there are various viewpoints and arguments there, which you can analyze. For example, with the state parties involved with interim, whether the interim measure of protection is within the arbitration agreement clause. All those were gone into, and the court took up the position and upheld that interim measures of protection granted by the tribunal was valid. There are very few case law on this point, because interim orders are generally, in most jurisdictions, when given, are honored, because you don't want to disturb the tribunal. So even in our act, in my opinion, if one were to dwell even to the preamble to the act, it gives an indication where interim measures of protection can be granted in courts. For example, it give effect to the convention of, that's a New York convention, and refers to certain sections of the Civil Procedure Code that is at the enforcement stage. Now, as you know, Section 40 of the Arbitration Act refers to the procedure for making an application to the High Court. Now, if an application is made to the High Court, in that 4 mandates the High Court to deal with every application expeditiously. So here, in my opinion, it would not be restricted to applications under Section 31 to enforcement. You may be able to use that interim measures of protection, Section 13, utilize this and ask for expeditious determination only on that point and to preserve the status quo. The other practical reality is, once you get an arbitral award after a hearing, and if the award is not honored, a party has 1 year to go to the High Court to enforce that award. What happens if the assets are dissipated or taken out of the country during that time? This is a practical problem. Then again, the whole arbitral process can become nugatory even after a hearing. Losing party might take the assets out of the jurisdiction of the country. Then it would be useful to see whether applications can be made to the court to again preserve the status quo till the enforcement of the judgment, enforcement of the arbitral award, and obtaining a judgment and decree of court. It is also possible then for the court to intervene and state that a judgment and decree is being obtained in the High Court, and before that, whether it's going to be a dissipation of assets. Therefore, in conclusion, I would say the whole purpose, as I said, of the Arbitration Act and dispute resolution is for the effective enforcement of the law. And if the effective enforcement of the law is going to be made nugatory, then interim measures of protection are vital. So very carefully monitored and done, it is going to be of vital importance in the future. Thank you, Janaka.
Thank you, sir, for that very informative presentation and lecture. It was very useful for all the practitioners, I think, who have subscribed today. And also, I must apologize for all the speakers for inviting them to speak on these mammoth-sized topics within 15 minutes of time. With that, dear participants, next we have yet another versatile lawyer, Mr. Harsha Fernando. Mr. Harsha will share with us his views and expertise on multi-tiered dispute resolution clauses, which comprise different steps and various alternative dispute resolutions, which are referred to as ADR techniques, such as mediation, conciliation, etc., prior to commencing of any formal legal proceedings. As you may be aware, there are many forms of ADR that contracting parties may agree for. For example, we have mediation, conciliation, adjudication, facilitated contract renegotiation, etc., etc. We even come across hybrid methods of ADR such as med, meaning mediation, arbitration, mediation. Therefore, as practitioners, we should be familiar with such other forms of ADRs as well. With that in mind, Mr. Harsha Fernando will lead us through multi-tier dispute resolution clauses and getting the maximum out of ADR clauses. Over to you, Mr. Fernando.
Thank you, Janaka. I'll start with a short presentation and try to see whether I could share my screen. I think the important thing is Hiran, just before me, referred to interim measures. Mediation and arbitration has to be looked at in two different lenses, in my opinion. The role of a lawyer is to offer a practical solution to a client who comes to you because there is a dispute for you to help to resolve using your skills and expert knowledge. So we keep using this word ADR, alternative dispute resolution, and for the longest of time, arbitration has been dominating the ADR literature. I've always questioned how does arbitration become an ADR process? An ADR to what? So alternative to what? So the obvious answer is court proceedings. And there's been a lot of literature on the benefits of arbitration when compared to courts. But today I like to impress upon you that if you look at the disputes and the mechanisms that are available to you to resolve or manage those disputes, then sometimes you might find that arbitration has a lot more similarities with the dynamics of a court process. Just as it has certain benefits, it also has certain similarities with the dynamics of a court process. And especially if you look at the experience in certain countries, including Sri Lanka, where we may not have fully fathomed the exact art of conducting arbitrations in the manner it should be, where they have become almost a substitute for court processes. As a lawyer, I think it's important for you to be able to advise a client the types of dispute settlement mechanisms that are available to a client, and not be one of those lawyers whose only solution to any problem is, let's go to court. So that's sort of the basis of today's presentation. And I think I'm very glad that Justice Nawaz mentioned Singapore Convention that was passed, that was signed or adopted in August of 2019. Sri Lanka is one of the 53 founder members. Of course, we have not ratified. We have only signed. Only 6 countries have taken the next step. So I don't know when Sri Lanka will do it. But the important thing about the Singapore Convention on Mediation is in the preamble, it recognizes the value of mediation, and also it recognizes the increasing use of mediation by international commercial agreements. So therefore, a case is already made that we should not limit our ADR expertise or choices to arbitration alone. The case is already made. Now, where does another mechanism like mediation would fit in once you have a dispute coming up? So to do that, the first thing that I would like you to consider is, what is a dispute? What is it that we do day in and day out in court, especially from a commercial angle? A dispute, whether it goes to court, commercial high court, or an arbitration, local or international, it's simply a business arrangement, a business deal that has gone south, that has gone bad due to some reason, maybe a major reason or a minor reason. But it's an underlying business deal that has gone wrong in some aspects. It is not a case for us to take on and turn it upside down. We have to respect the fact that it is a business dispute. There's an underlying business arrangement that is supposed to create value to the two parties to that business and to the rest of us, the consumers or society or whoever, in the context in which that business arrangement took place. So let me see, Janaka, whether I can share my screen. Can you please confirm whether you can see it when I...
yes, not yet.
Can you see it?
No, we don't see it at the moment, sir.
Okay, let me check.
Not yet.
You can't see it, right?
No, sir. Unfortunately.
No, I think there's a problem. Okay. So what I would do is, okay, I'll try to explain this without the benefit of the slides. Sorry about the technical glitch. Basically, if you look at disputes, out of the available mechanisms for you to deal with, your first choice is, are you going for what we call an adjudicatory process or a non-adjudicatory process? So the adjudicatory process simply is where you go before a third party like a judge or an arbitrator, present both sides of the case, and then tell the third party to decide. A non-adjudicatory process is slightly different, where you get the support of a third party to help you to reach an amicable and a mutually acceptable solution, an outcome. In Sri Lanka, it's already recognized under our Mediation Boards Act, as well as the Commercial Mediation Center Act, which, similar to the Arbitration Act, prohibits a court to entertain a case if there is a mediation clause, which, of course, unfortunately, the access recognizes the principles of that act. So that principle is recognized. So when you decide whether you want to go for an adjudicatory process or a non-adjudicatory process, your decision is based on two things. That is, how much control do you want to have over the outcome of the case or the dispute, and how much control do you want to have over the procedures. If you want to have a lot of control over procedures, arbitration is a good mechanism where you go for ad hoc, and then you agree at the parties at the arbitration, this is the procedure we follow. But then you will not have control over the outcome, because once the arbitrator gives an award, you have to accept it. There is no, that's the end of the process. On the other hand, if you agree to mediation, it's simply where third party helps the disputants to come to an agreement. The mediator will help you to, mediator might set the rules of procedure, but at the end of the day, if you don't like, you can walk away. Now, the question you need to ask is, what is the mechanism that I will choose? Now, for you to take that decision, you need to have a good understanding about the conflict itself. What is the dispute? What's the nature of the dispute? Please don't be a lawyer that advises for any dispute to run to court. You will have to look at the terms of the agreement, what can be proved, the time that it will take, what can be needs expert opinion, how many experts. You take all those into account, and then understand how the dynamics will affect parties. If you take a court case, when we go to court, we have only two outcomes. Either we will win or we will lose. That's it. So how we behave is we work backwards. That's why we tend to not disclose information, critical information. We play all kinds of tricks during the trial procedures. But at the end of the day, it's the clients that lose out on more value being created. Now, as a result, even if you win the case, you have actually lost a lot in terms of time, costs, transactional costs, relationship costs, things like that. Now, the mediation is slightly different. There, you do not go with a mindset set, either I'm going to win or lose, but you rather go and see, okay, we got a dispute. Hopefully, we can resolve it. Now, how can we move forward? Sometimes you might actually make a better deal than the status quo ante to the dispute. That's very briefly mediation and arbitration, the difference. Now, the question is, how does that fit into a commercial contract? So these multi-tiered arbitration clauses or multi-tiered dispute settlement clauses are designed in such a way that it allows a dispute to escalate to the next level if you can't resolve it at a different level. So in most commercial agreements, it starts with negotiations. So there the clause will say the parties will in good faith endeavor to negotiate if there is a dispute. If that doesn't work, then you can have a third party come in who is a mediator, and with the help of that mediator who will help you to resolve your communication challenges and things like that, then try to resolve. If those two don't work, then you can say, fine, let's refer this to a third party, an independent neutral third party called an arbitrator, and let that party hear both our cases on an adversarial setting and then decide who should be awarded and who should lose. Now, both first and the second, the negotiation and mediation, you will have a lot of control in terms of deciding whether you want to finally get it or not. The good thing is, if you come to a settlement based on a mediation or a negotiation, you can be very sure it was not something forced on you. It was something that both parties agreed to that will ultimately benefit both the parties in the long term in terms of implementing the contract further. Don't forget, we are still dealing with an underlying business arrangement that is supposed to create value. That benefit is not there if you decide to go to arbitration or to courts. So when you design a multi-tier arbitration, a multi-tier dispute settlement agreement, have that in the back of your mind. The first thing that I would advise you to do is understand what are the possible conflicts, disputes that the parties to this particular agreement might constantly face. And once you have got a general idea in consultation with your client, then come up with a few dispute settlement options that can range from negotiation, mediation, arbitration, and a few others like expert determination, independent neutral third-party evaluation. There are a few others, but let's stick to the main three. So you present that option to the parties and then include in the clause. The important thing is when you draft the dispute settlement clause, and if you have a pre-arbitration agreement like mediation, please very specific whether it's mandatory or whether it's optional by the use of the word shall or may. And also be mindful of the fact, remembering what Hiran mentioned to you about interim relief, that one party should not use these pre-court or pre-arbitration clauses to delay the process. But in my experience, if I am given a choice, and I'm increasingly becoming convinced that that is the case, especially after experiencing arbitration in Sri Lanka, I'm encouraging my clients to shift towards negotiation and mediation. And if those two fail, then go to courts, bypassing the arbitration clauses, which of course is very difficult when you're dealing with international agreements. But at least for local agreements, that is something that I'm beginning to encourage people to do. In construction contracts, for example, this kind of multi-tier mechanisms are already in place because of the nature of the contract and the disputes that it tends to arise. So my final thought that I would like to leave in your minds is, as a lawyer, you're a conflict doctor. Understand why your advice is sought. And your advice should include both how you deal with the dispute. That's the process, mediation or negotiation or arbitration. And then, of course, the substance of the dispute. That's where your legal knowledge on contract law and all those things will come into place. So given that, try to develop your skills. Mediation cannot be done by laypersons. I think it needs very specialized training. It's more difficult than arbitration, in my opinion. But it can be done. And it is a skill that every lawyer, either you must get it or at least be aware of it. Because now the world is looking towards us to give those multiple options, because nobody wants to waste their time in courts, but to get the dispute sorted quickly and move on to the next phase, because we cannot afford to waste our time or resources. Thank you.
Thank you, Mr. Fernand, for those practical tips and application of certain ADR techniques. I think we were better off without the slides also. You were always a good presenter, and we enjoyed thoroughly your presentation. With that, we move on to last but not the least, the panelist for tonight, ladies and gentlemen, is Dr. Asanga Gunawansa, who needs no introduction when it comes to arbitration. He is well versed and experienced in international arbitration by acting as an arbitrator and counsel himself. Dr. Gunawansa will address us on the changes necessary for the existing Arbitration Act number 11 of 1995 and related laws, taking into consideration both global and local developments in the field of arbitration, especially in the field of international commercial arbitration. Without much ado, let me now invite Dr. Asanga to address the participants.
Thank you, Janaka, for that very generous introduction. And I think I can take the cue from something that was mentioned by Harsha in making my presentation. As Harsha mentioned, not only him, I know quite a few lawyers who now discourage parties from adopting arbitration clauses into their agreements in Sri Lanka, especially in domestic contracts, for the reason that arbitration has actually not worked in Sri Lanka as initially anticipated when the Arbitration Act was first introduced almost 25 years ago. Now, as you know, most other laws in Sri Lanka regularly go through a process of amending in order to deal with the changing needs. However, our Arbitration Act has not gone through that change. As Justice Nawaz mentioned in his talk, even the Ancestral Model Law, which was initially introduced in 1985, was subsequently amended in 2006. The Singapore Arbitration Act, both domestic and international, have gone through several amendments. The UK Arbitration Act has been amended several times. Indian Arbitration Act has been amended several times, but the Sri Lankan Arbitration Act remains the same. We are almost 25 years. And as a result of that, we are having some issues. So given the fact that we have been allocated, a very brief time to deal with it, I'll jump straight to some of the issues. There are about 10 to 15 issues to be dealt with, but I'm not going to deal with all that. I have picked about 3 or 4, which we can discuss during this short time frame. So having said that, let me share my screen. Let's see whether you can see that. Janaka, can you confirm if you can see this?
Yes, we can see you. We can see your slides, Doctor.
All right, excellent.
Thank you.
Right. So one of the first points that I wanted to highlight is the recognition of agreement to arbitrate. Now, universally is recognized that an agreement to arbitrate is can be contained in a commercial contract as an arbitration clause, or you can have a separate standalone arbitration agreement. Either way, it's a standalone clause which even can survive in certain situations if the main agreement is made null and void. Now, the Sri Lankan Arbitration Act, as well as the Untitled model law and arbitration statutes of most other common law jurisdictions that I have examined, basically say that there has to be evidence of an arbitration agreement that has been reduced into writing by the parties to recognize that there is an agreement to arbitrate between the parties. Then the language that is found in the model law gets tweaked, depending on the local needs in different jurisdictions. But I would like to highlight one particular aspect that you can see in Article 7.4 of the model law, which says the arbitration agreement must be in writing, must be met by an electronic communication if the information contained therein is accessible so as to be usable for subsequent reference. So even there was a recent decision, I think, but that is of course in a civil law jurisdiction in Germany, if I'm not mistaken, where exchange of messages in the form of WhatsApp was recognized as constituting an arbitration agreement between the parties to the dispute. Now, this language that I just read out, which is in the model law, is not found in the Sri Lankan Arbitration Act. So given the fact that we are now into online arbitration, right, especially in pandemic situation, and also electronic documentation and electronic contracts are widely in use, we might have to look at the need to revamp the clause in the Sri Lankan Arbitration Act, which recognizes what an arbitration agreement is. The second issue that I want to highlight is a very contentious issue. I think Justice Nawaz also very briefly dealt with this. That deals with the principle of competence. Now, the principle of competence, the basic premise of this principle is that once the parties have agreed to refer a dispute to arbitration, then the arbitral tribunal itself has the authority to determine its own jurisdiction. However, by way of statutory development, this basic concept has undergone some tweaks in different jurisdictions. And as a result, today we have three main approaches. The first approach is that the jurisdictional questions can be posed only to the arbitral tribunal and to no one else. The second approach is that the jurisdictional questions can be posed to the arbitral tribunal or to the competent court. So it's not a situation where you can have your cake and eat it. You either raise it with the arbitral tribunal. If not, you can raise it in court, but you can't do both. The third situation is the preferred approach, I would say, is where the jurisdictional issue can be raised with the arbitral tribunal, let the arbitral tribunal decide, and if a party is dissatisfied with the ruling of the arbitral tribunal, then an appeal could be made to the competent court. Now, this is the approach that you can find in the Untitled model law. This is the approach that you can find in the Singapore Arbitration Act, the Indian Arbitration Act, the Australian Arbitration Act, and the English Arbitration Act, to name a few. So if we make a comparison of the two clauses, I have picked up the clause from model law, Article 16 and Section 11 of the Sri Lankan Arbitration Act, you can see the difference. Now, if I may very quickly read, Article 16.1 of the model law says the arbitral tribunal may rule on its own jurisdiction, including any objection with respect to the existence or validity of the arbitration agreement. Now, from there, if I jump to Article 16.3, this is what it says. The arbitral tribunal may rule on a plea referred to in paragraph 2 of this article, either as a preliminary question or in an award on the merits. So award on the merits is made at the tail end of the arbitration, having heard evidence. So the tribunal can decide on a jurisdictional objection either at the beginning or at the end of the arbitration. Then it says, if the arbitral tribunal rules as a preliminary question that it has jurisdiction, any party may request within 30 days after having received a notice of that ruling, the court specified in Article 6 to decide the matter, which decision shall be subject to no appeal. So now the model law says by some chance, if the arbitral tribunal decides that they have jurisdiction as a preliminary issue, and if one of the parties is not satisfied with that decision, that is the tribunal assuming jurisdiction, then they can, in terms of Article 6, go before the competent court and appeal from that decision. Now, if you look at the Singapore Arbitration Act, if I'm not mistaken, it gives a period of 90 days or 30, maybe 30 days. The UK Act gives 90 days to appeal to the competent court. However, when you come to the Sri Lankan Arbitration Act, we have some very strange language here. It says an arbitral tribunal may rule on its jurisdiction, including any question on any question with respect to the existence or validity of the arbitration agreement, or as to whether such agreement is contrary to public policy or is incapable of being performed. But any party to the arbitral proceeding may apply to the High Court for a determination of any such question. Now, when you compare, the model law says, if the tribunal decides they have no jurisdiction, that's the end of the matter. But if the tribunal decides they have jurisdiction, then you can make an appeal to the competent court. But the Sri Lankan Arbitration Act creates parallel jurisdiction. Now, this is a provision that you can't find in any other statute anywhere else in the world. So very strangely, what happens is this section is being misinterpreted quite a bit. And as a result of that, in Sri Lanka, under Section 11 of the Arbitration Act, there are parallel applications that are being made both to the tribunal and the competent court, that is the Commercial High Court, simultaneously. Sometimes applications are made, they wait for the tribunal to decide. If the tribunal says no jurisdiction, they come before court and make an application for the court to either decide whether the tribunal has jurisdiction or not. On the contrary, if the tribunal says that it has jurisdiction, then an application is made under Section 11 to the court to make a decision on this. Why I say this is very strange is that Section 26 of our Arbitration Act, and if one reads Part 7 of our Arbitration Act, which starts with Section 32 onwards, which clearly says when the arbitral tribunal makes a decision, the only circumstances in which one could make an application to court against such decision is found in Part 7 of the Arbitration Act. So that is when it comes to an appeal from an arbitration award, or when it comes to making an application for enforcement when an arbitral award is made. Now, both these things happen once the arbitrators have gone through the merits of the dispute and made a decision. Part 11, Section 11 of the Arbitration Act is found in Part 4 and not in Part 7. So therefore, there is, as far as the Sri Lankan Arbitration Act is concerned, nowhere does it say that you could, once you raise the jurisdictional objection before the tribunal, and you can also make a parallel application to the court, or you can make an application to the court by way of an appeal. And if somebody does that, that's the wrong procedure, but unfortunately, it has been done. But we are yet to see any decisions on this matter, and let's hope that Justice Nawaz or one of his colleagues in the Supreme Court or colleagues in the Supreme Court will have the opportunity of dealing with this issue so that we will have clarity going forward. Another section that I would like to highlight is Article 17B of the Model Law, which enables the arbitral tribunal to grant interim relief, not only to preserve the status quo, but it says to take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself. So this section has been made use of in jurisdictions where it has been adopted to take action against parties who try to stall the arbitration process or to make various other contemporary parallel applications to courts in order to delay the arbitral process to prevent that. But we don't find this language in the Sri Lankan Arbitration Act. So this is also something that we might have to think of. Then Article 33 of the Model Law provides for a party to dispute to request the arbitral tribunal to correct any error in the award within 30 days of the award. Now, the Sri Lankan Arbitration Act only provides 14 days, and I don't think that time period is adequate, especially going by the practices that are, or the practice of the local arbitrators. To give you one example, we are currently in an arbitration where a preliminary jurisdictional objection was raised as to the jurisdiction of the arbitrators approximately 1.5 years ago, and which involves an international party as well, a local state sector entity and an international contractor. And now approximately 17 months have passed, but still there is no order made on the jurisdictional objection because the 3 arbitrators are very busy and they can't find the time to meet. So we have issues like this, and therefore I think even when it comes to correction of awards, giving adequate time, right, would be a meaningful amendment that can be introduced. Then when it comes to definition of arbitration agreement, the definition contained in section 50 of our Arbitration Act is insufficient and requires to be amended to be in line with the modern technology and growth of online arbitration. And as you know, currently even most of the international arbitrations are conducted online. So in that situation, the awards that come out of those online arbitrations may sometimes not fall within the current definition of an arbitration agreement that we have. I touched on that point earlier also. Then most countries have enacted legislation both enabling domestic arbitration and international arbitration, and as a result of that, there are separate statutes. This again is something that we might want to consider, because domestic arbitration may require more supervision by courts compared to, or more intervention by courts compared to international arbitration. And my final comment for today is that our Arbitration Act is simply not geared to deal with multi-party arbitrations. So if one reads section 7 of the Arbitration Act, it's very clear that our Arbitration Act contemplates disputes that are referred to arbitration and in connection with application may be made to court where there are 2 parties involved. But as you know, in the current context, especially when it comes to development contracts, most of the contracts are multi-party contracts or tripartite agreements. In situations like that, there might be disputes which may involve more than 2 parties. So we need to have provisions in our Arbitration Act to deal with multi-party arbitrations, which we don't have at the moment. But if one looks at for example, the Singapore Arbitration Act, it is pretty well equipped to deal with multi-party arbitration. Confidentiality of the obligations. Confidentiality obligations is also something that we need to look at. In some jurisdictions, recent amendments have been introduced where the courts can get involved in order to enforce confidentiality obligations arising out of arbitration, and specific language has been introduced into the arbitration statutes to do that. This is also one thing that we might want to consider. So that's what I have for today, and I'll be happy to answer any questions if anybody has any questions to me. Thank you, Jonathan.
Thank you, Dr. Gunawansa, for that eye-opening session on what we have as legislations and law at the moment and the requisite for amendment. Thank you again. So with that, ladies and gentlemen, we will straight away move on to the Q&A session. There are a few questions that needs to be posed to each of the panelists. I presume, given the time constraints, your answers should be limited to not more than 2 minutes. So my first question goes to Honorable Justice Nawaz. Sir, now you spoke about several scenarios where the judiciary has intervened into arbitral awards, proceedings, etc., etc. What is your view and opinion on anti-arbitration injunctions, where the arbitration proceedings will be stopped, maybe provisionally, by a competent court of jurisdiction?
Well, I think the anti-arbitration agreements are rooted in Section 11 as Dr. Asanka Gunawansa pointed out. Now, I said that at the beginning that the arbitration agreement can be, you can hear me, right? Can be impugned in court as being obnoxious to public policy, right? In other words, when somebody files it in the High Court, say a case is filed, but there arbitration agreement, there's a bar. But you can overcome that bar, but it's pathological. If the arbitration has commenced, then the court stops that arbitration by issuing an anti-arbitration injunction. So now, you can make that application, as Asanka pointed out. There is a parallel jurisdiction created by way of Section 11 of the Arbitration Act number 11 of 1985, because I think I showed that in my presentation as well. It says, but any party to the arbitral proceedings may apply to the High Court for a determination of any such question. In other words, an original jurisdiction is created there. You see, it's not an appellate jurisdiction. Model law speaks about an appellate jurisdiction, but Section 11 creates an original jurisdiction. That is where this confusion is. So that's open to abuse. And I think I also used Section 11 at some stage of my my arbitration practice, right? But then now, in retrospect, when I look at it carefully, and even Redford and Hunter also says that there has to be an appeal. You can't create for good reason. And and I also agree with Asanka for having two laws, because if you look at Singapore, all arbitration-friendly countries have two statutes, one for domestic and one for right. So it's a matter for national legislature, and then, so that's the answer for it.
Thank you, sir, for that.
I'm against. I must tell you, I'm against anti-arbitration injunctions. Right.
We are very pleased to hear that, sir. Thank you for that answer. So my next question goes to Mr. Hirandi Alves. Sir, now we know that you have been involved in a very leading arbitration institution or a center in Colombo, and in view of that, would you think can interim measures be obtained through arbitration centers? What's your opinion on that?
Well, locally, that is not possible, fortunately or unfortunately, for practical reasons. But compared to, say, Singapore International Arbitration Center rules, or where they specifically now provide for interim measures of protection. For example, sometimes they can have an emergency arbitrator who is not even the arbitral panel to act immediately and preserve the status quo. But as per our institutional rules, it is not possible unless the parties have adopted the institutional rules through the centers. For example, the SLNAC recommends the UNCITRAL arbitral rules. So if they adopt the rules, then of course interim measures are possible. Otherwise, it's not possible.
Right. Thank you, sir. Understood. My next question goes to Mr. Harsha Fernando. So now, there are multiple ADR mechanisms. If there are multiple ADR mechanisms available, as you said, especially something effective like mediation, why is it that we don't find many mediation clauses in our commercial contracts? That's my question to you, sir.
I think there are three answers for that. First, I think you find mediation clauses in certain types of contracts, like construction contracts, where they have evolved to deal with disputes in a more sophisticated manner. I think the two main reasons why we don't find a lot of mediation clauses, number one is the perception that both the contracting parties as well as the lawyers have in their mind that a mediated agreement cannot be enforced. And number three is we do not have because of that, it has not got mainstream. Even at the point of especially drafting the dispute settlement clause in a commercial agreement, it is referred to the lawyers for their advice. The business people will do the business agreement, but putting it in legal form and dealing with dispute settlement clauses is referred to lawyers. So when you go to lawyers, if you do not have in your tools, the multiple dispute settlement mechanisms that are available to you, you will tend to advise to only limit to one or two areas that you are very knowledgeable about. So I think we need to broad base the conflict dynamics, and in that context, the mechanisms or tools available to deal with disputes differently, and especially in commercial matters.
Thank you. Understood, sir. Yet another question. This question goes to Dr. Asanga Gunwan, sir. So now you discussed about certain provisions in our existing act and dealt with certain scenarios where we need improvement and development. What statutory measures are required to promote Sri Lanka as a preferred seat of arbitration, in your opinion, with your experience?
Thank you, Janak, for that question. But I think all the changes that I mentioned and the changes that I didn't have the time to mention today, given the short time frame, needs to be looked at if we are to promote Sri Lanka as a preferred seat of arbitration. That is from a statutory perspective. But quite apart from a statutory perspective, there are certain other measures that we need to take as well. Now, say, for example, at any given time in Sri Lanka on any given day, I'm sure, hundreds of contracts are being entered into with international parties, especially by the state sector, right? And in all these contracts now, because when the moment a foreign entity is involved, they would not want to subject themselves to local domestic, courts when it comes to jurisdiction. So therefore, their preferred approach is to have international arbitration. Now, one of the reasons as to why I can understand having the ICC arbitration or the LCIA arbitration rules, applicable to arbitration. But when it comes to even venue, seat of arbitration, the preference now is to either choose Singapore or Hong Kong or London or something like that. And this is a very expensive exercise for state organization. But they have to agree to this because we don't have a well-equipped, well-recognized seat of arbitration to put forward, right, in order to have, our local arbitration. So when I say a seat of arbitration, two aspects. One is the applicable law, and I have already highlighted the problems with our law, right? And the second one is, the arbitration practice itself here, the role played by courts sometimes, one example is, and both Justice Nawaz and I spoke on Section 11, and I know one application that was made in Section 11, 5 years have gone by, now is lying in the Supreme Court, right? And then there is another case where nowhere in the Arbitration Act says that the Court of Appeal has jurisdiction, but a particular party wasted 3 years making a revision application to Court of Appeal, right? And that is one. This is why Sri Lanka is ranked like 195th or whatever out of 200 countries when it comes to enforcement of contract. So we need to have a proper policy in place, not only to amend the act, but also make the necessary institutional changes as Iran suggested in order for us to promote ourselves as a seat of arbitration. And if we do that, I think there's immense potential, right? If you take the South Asian region, we are like 1/5 of the world population lives here. And some of the largest India, Bangladesh, Nepal, the type of contract that they're entering into, they would be Pakistan, they would certainly prefer to come to Sri Lanka than going to expensive seats such as Singapore and Hong Kong or London. But we have not taken an initiative. I will sum up by saying this: you all know how the Sri Lanka International Arbitration Center at the World Trade Center was ceremonially opened 5.5 years ago. And the government preferred to pay 3.5 million rupees rent, but didn't give any seed money to have a secretariat, set up to run the place. So
I can vouch for that, sir.
Yeah. So that's my response to you.
Thank you, sir, for that. And there are couple of questions from the audience also. I want to take up those one or two. Nadun Fernando has raised this question. Does intention of parties matter in interpreting an arbitration clause, especially in considering enforceability, or it is mere verbatim approach? I will like to pose this question to Dr. Gunawansa maybe.
I think Justice Nawaz is here. I think he will be the best person to respond to that, because I can also learn from him.
Yeah, because,
Justice Nawaz, please.
I just had a Singaporean decision, right? Now, see, it's very important that our courts have to be very proactive in creating the image that we are an arbitration-friendly judiciary. If you don't have that, you can't promote direct investment and things like that. Now the case that I was reading up yesterday, now you have that famous arbitration center in Singapore. The SIAC, right? Now in that SIAC rules, SIAC said, now the arbitration clause said, ICC rules, the arbitration must be conducted in accordance with the ICC rules. SIAC said, well, we will administer the arbitration. We will use the arbitration. CS use the rules. We will administer the ICC rules here, not the institution. And irregular procedure is it's perfectly all right. I heard very relaxed. That was challenged, right? And it was taken all the way to the High Court. So now we should get away from this type of. The judges have to be proactive and reject these kinds of things and then create confidence. Then we will certainly rank as one of the best arbitration-friendly countries. As Asanka doctor said, we have to amend the law. We have to, the judiciary has to be proactive. Then now I read another case. You can just Google that. ASTO, ASTO versus LIPO. Right. The case was heard in the High Court. The High Court of Singapore said you can't enforce this award against certain non-signatories. In other words, nobody tried to even set aside it. In the enforcement court, the Court of Appeal Singapore said you can't enforce this because against the non-signatories. You know what the award winner, the award creditor did? He took the award all the way to Hong Kong and then tried to enforce it in Hong Kong against those non-signatories, mind you, right? In 3-4 lines, the Hong Kong Court of Final Appeal said, Singapore court has spoken, right? There is issue estoppel which operates here. We are bound by that decision. And so now you can see how the Singaporean decisions is respected in the High Court there, in the Court of Appeal in Hong Kong. So that is the kind of culture we have got to develop, right? So if we develop that, we will certainly rank high in the enforcement of contract indexes and even in our arbitration domains.
Thank you, sir.
Yeah.
Yes. Thank you, sir. I would like to direct this question to Mr. Hirandi Alvis. Chamit Senanayake joining with us raises this question, sir. What are the pluses and minuses of applying the procedural code within brackets, civil procedure, etc., in arbitrary proceedings, again brackets, compared to ad hoc procedure?
Well, short answer is civil procedure code should not be followed
Right.
Purely for the reason that arbitration is alternate dispute resolution, and the parties are at liberty to adopt their own procedure. However, it can be used as a guideline for the efficient conduct of the arbitration if they so want. Actually, the Arbitration Act provides for an arbitral tribunal to create its own rules of procedure. That is there in the Act. In fact, I would advocate that rule to be used to expedite the arbitrations. For example, with imposing timelines. So, only thing is the Civil Procedure Code, as I said, or the law can be used as a guideline to make sure that due process is followed. Because that is also vital in arbitration, that due process and natural justice, etc., are followed. So you don't need the civil procedure per se. That's the short answer.
Right. Thank you, sir. Suffice. My next question goes to Mr. Harsha Fernando. Sir, now, when it comes to mediation, who can engage in mediation? What kind of, can any person be engaged in mediation?
My short answer is no. I think mediation is a separate skill set. You need to be trained in mediation to be a mediator. I do not know whether Sri Lanka offers formal training in mediation. Number two, if you're offering mediation services, there is a whole legal regime that should come into place. The agreements that you sign with the parties to mediate. And then if the mediation results in an agreement, you can enter it into, you can again include those terms into an agreement, and it can be enforced through courts as if it's a new agreement. So I think you need two things: the skill set to mediate in disputes, and then a separate sort of a legal regime, a contract regime that should be there between the mediator and the two parties.
Thank you, sir. Thank you for that. So my final question for today, somewhat a long question from Mr. Jayasiri Samaratunga. I would like Dr. Asanga, if you can answer this question. I quote, Honorable Sirs, when there is a Geneva disputed by shareholder or shareholders, it has not provision to go for arbitration, and it has been prevented or avoided by under the Companies Act, under Operation and Mismanagement Clauses, sections 224, 225, 226, prescribing that on such situations, shareholders have to apply to courts. What's your view on that? Very short answer.
Yeah, Janaka, I saw that question. The question was not very clear to me, but from what I understand what the question is, what I can say is this. Now, arbitration is a good process for resolution of disputes, but it may not be a good process for every type of dispute. So especially in regulated industry, now companies is a regulated industry, and we have very comprehensive Companies Act, and there are specific provisions available within the Companies Act to make an application to court. So in that situation, going before the court would be the most appropriate thing. So unless there is some form of a shareholders agreement, under which agreement to arbitrate is already there between the parties, then there will not be provision for you to go to arbitration, because the chance of a company agreeing to arbitrate a dispute of this nature, what has been referred to in the question with a minor shareholder, is very, very remote. And that is why those provisions are contained in the Companies Act. So that is my response.
Thank you, sir. That will be very useful.
If I may come in there, it turns on the arbitrability question. In other words,
that is so.
We have arbitrable matters and non-arbitrable matters. So then, right.
Thank you, sir. I think with that, we have come to the conclusion of a very informative and interesting session today. Unfortunately, we have almost run out of allocated time for today's session. I make this opportunity to thank all the speakers for being here and educating us on these valuable points, despite their busy schedules. I must say, Honorable Justice Nawaz participated in a long seminar, workshop today, the whole day. And despite all of that, he very generously promised to, participate in this webinar. Thank you, Your Lordship, for being here, and all the other speakers, Mr. Hirandi Alves, Mr. Harsha Fernando, and Dr. Asanga Gunwansa, sharing with us your knowledge and experience and expertise, and especially your vision towards the development of ADRs, especially arbitration and mediation in our country. I must also thank and convey my heartiest gratitude towards the Bar Association, the President of the Bar Association, Mr. Kalingi, the President's Council, the Secretary, Rajiv Amarasuriya, and all the other office bearers for organizing these kind of webinars in a tried and a turbulent time, which is of very use for, especially for junior lawyers. I must say there are a lot of junior lawyers who are subscribing to these programs. And last but not the least, I must thank the participants. We see a lot of judicial officers as well as senior members of the bar also attending this session. Thank you, ladies and gentlemen, for your kind participation in this webinar. And I do hope that you will have a peaceful and a blessed season and a peaceful holiday in time to come. Thank you.
Thank you.
Thank you, Janaka.
Thank you.
Thank you.